The 4th day of June, A.D. 1992, fell on Thursday. So, in fact, be it remembered that upon the 4th day of June, A.D. 1992, the above entitled and numbered cause came for said proceedings before the Honorable C.V. Milburn. That's not a name. C.V. Presiding Judge of the 174th Judicial District Court of Harris County, Texas, and the state. But Jesus said, every kingdom or household divided against itself shall not stand. Thus, the attorney representing the so-called state of Texas is employed by the same state of Texas. The trial judge or presiding judge of the case is employed by and serves for the sole state of Texas, and the attorney for the defendant, my Facebook friend and former attorney, Russell M. Webb, there's no one has a middle name, M, attorney at law, was appointed by the state of Texas. So, how can I win? All three against one. The purpose for me creating this video is to read what this elderly retired judge from Odessa, Texas, had to say to the prospective jury panel during voir dire, which is a French word, means to speak truth. So I will read from this instrument, which is also called the court reporter's notes. At that time, we referred to it as the statement of facts. So it reads: Proceedings, June 4, 1992, by Mr. Mankey, in the name and by authority of the state of Texas. The duly organized grand jury of Harris County, Texas, presents in the District Court of Harris County, Texas. There is no such court known as the District Court. That would make the indictment jurisdictionally defective. That in Harris County, Texas, Ronald Dwayne Whitfield, hereinafter styled the defendant, heretofore, or on about December 10, which fell on a Tuesday, 1991, did then and there unlawfully with intent to commit theft, mens rea, Texas, making law as if she's a witch doctor or God knows what a person's intent is before they do an act. But I won't interrupt anymore until I get to the part where I'm going with this. So, did then and there unlawfully with intent to commit theft enter a building not then open to the public, owned by Edith Creasy, a person having a greater right to possession of the building than the defendant, and hereafter styled the complainant, without the effective consent of the complainant, namely without any consent of any kind, against the peace and dignity of the state. There is no such thing known as the state. That's another jurisdictional defect. I wouldn't give a damn what the legislature has said through her members. There's no such thing as the state, unless we are to presume that they're talking about the state of Texas. The state. Signed by the foreman of the grand jury. You cannot make out that so-called name. You have to record your name on instruments so we can know who you are. Texas have gotten away with this evil too long. You want to call this grand jury member a purported foreman? You can't, because you can't make out what you call a signature. That's not how you. Well, okay, I don't want to get upset for nothing. They do this intentionally. I never sign or record my name where you cannot discern who authored or signed the writing. All right. Grand jury. The court cannot talk, so it should read the judge. You've heard the reading of the indictment, Mr. Whitfield. How do you plead? Guilty or not guilty? Had I only known what I know now, I would not have entered any plea. The defendant, in all caps, incorrect. Not guilty, Your Honor. The court again. A court cannot read, write, spell, see, talk. She does all this through a presiding judge. Okay, have a seat. Page 3. The reason why I have to be so specific, because the government, try to either kill me or lock me up for the rest of my life, one or the other. So I have to protect myself. There, period. I would like to welcome you here this morning, ladies and gentlemen. My name is C.V. Milburn. I'm a retired judge from Odessa. I'm sitting in for Judge Godwin, who is in the process of trying another case. This is a criminal case. Of course, it's going to be the jury's job to decide the disputed facts. The way you get in the courthouse on a criminal case, as far as you are concerned, is by way of indictment. That's simply a piece of paper which contains the elements of the offense which the state, what is the state? I guess he means the state of Texas, who is also, having her judge try the case, her prosecutor try the case or prosecute the case, and the attorney that she appointed. And somehow I'm supposed to get a fair trial. Jesus said this is bullshit. Every king, look at Matthew 12, verse 25. Jesus said that's bullshit. And Jesus also said you cannot serve two masters. Either you're going to love one or hate the other. He was so right. Where was I? The state. Let me find that term again. That phrase. It's required to prove. Just say what it is. The attorney representing Harris. The attorney. The lawsuit, criminal action is brought by the Harris, in this case, was brought by the Harris County District Attorney's Office. It is a creature, or it is an office constitutionally created, but it is not the state. Okay, where was I? Okay. The state is required to prove by legal and competent evidence beyond a reasonable doubt. I want to talk about evidence. Evidence can be misleading. Proof cannot ever be misleading. Unlike evidence, proof removes all doubt. The term reasonable doubt does not have a legal definition that's what he wrote. That's what he said, or that's what is typed here. The term reasonable doubt does not have a legal definition in Texas until last November. So therefore, the term reasonable doubt did not have a legal definition in Texas until last November. And for the benefit of those who may have sat on a criminal jury. Well, anyway, we have a legal definition of reasonable doubt. Now, I'm sure the attorneys will go into it with you. The definition of it is quite lengthy. The defendant, as he sits here today, is presumed to be innocent. That presumption remains with the defendant throughout the trial, and he's presumed to be innocent. That, page 5, presumption remains with the defendant throughout the trial until the state, whatever that is, if it can prove his guilt by legal and competent evidence. Never again will I let these hoes have me stand trial and my life, or rather the life God gave me, freedom of property, is subject to what they call evidence as opposed to proof beyond a reasonable doubt. The defendant is not required to testify in this case. If he failed to testify, that cannot be taken as a circumstance against him. I know a lot of people say, quote, I want to hear both sides, unquote. Well, under our jurisprudence, you are not entitled to hear both sides of the story unless the defendant and his lawyer decides you are going to hear it. Now, is anybody going to hold it against the defendant if he do not testify, period? The law does not require that he testify. I tell you, that's strictly between him and his lawyer. Now, I know who, now I don't know who the witnesses are in this case, but a lot of jurors seem inclined to believe some witness or another because, now let me back up. This is what I want you to know in relation with CPS, in relation with the Harris County Attorney, and in relation with the judge in this case, in the CPS matter. I won't refer to it as a case, but only as a matter. Judge John Phillips. The allegations were brought by hearsay. When I say hearsay, I mean that the investigator in this matter was Paul Gonzalez. He related this information to the Harris County Attorney. And in turn, the Harris County Attorney typed up what we call a petition and caused it to be filed along with orders that the judge himself did not file, and that would supposedly constitute a case. Neither Paul Gonzalez nor the attorney that brought the matter to the district clerk for filing are witnesses. They have no personal knowledge of any conduct in which it is alleged that I engage. You see how this works? So, do they have standing? Does the office of the Harris County Attorney have the standing to bring, without personal knowledge, a petition against me based on what someone said, which was not sworn? Therefore, no one can be held accountable because none of this shit was sworn to under perjury? Come on now. But listen to what this judge is saying. In this criminal matter, it wasn't also a case. Now, I don't know who the witnesses are in this case, but a lot of jurors seem inclined to believe some witness or another because of his or her occupation. You're not supposed to give someone working for Memorial Hermann Hospital any more credibility. You're not supposed to give any more. Okay, there you go. You're not supposed to give any more credibility to a police, a doctor, a preacher, or anybody else, such as them two women that you see in the video one telling me I cannot record and the other one refusing to give her name any more credibility than you're going to give to me, Judge John Phillips. You never gave me a chance to even get to the court. You never came out to the bench. You never came on the bench. You signed orders without holding the hearing, without making findings of fact. You can't do that. That'll get your old ass locked up. Fucking with me. Fucking with me, you will be locked up. I demand his ass be locked up. You know damn well you cannot sign and file orders without conducting a hearing. You don't give no motherfucker because he employed by Herman Memorial Hospital credibility. It gives them more credibility than you give me just because of their motherfucking occupation. Just because they happen to be employed by Memorial Herman Hospital, you gotta take my child away without giving me affording me an opportunity to be heard. I've yet to be heard today. For those of you that do not know, this old ass judge has not. I got him recorded. I back up, I prove, not with evidence, but prove what I allege. Moving on. I don't show no damn respect to a corrupt, old ass judge. When I say old, I mean when you get old, you're supposed to become wise. It's one thing to be young and stupid, and another to be old and stupid. People don't give a damn about being shown. They don't. People read Proverbs and about people. You see people 60, 70 years old, just as stupid as hell. People in their 40s, been in the world 40-something years, still acting like stupid, unsophisticated. I got 24 minutes. Okay. Now, I don't know. I've read that. You are the sole judges of the credibility of the witnesses. And you look at them and you make up your own mind. Or not. You want on mind on whether or not you want to believe them. I've tried police. I've tried preachers for felonies. I've tried policemen. I've tried lawyers. So you can't just say because somebody has a certain occupation, like these women that make these false charges against me of child abuse. See how the video shows they lied? That just, the fact that it will make him or her believable. Anybody going to believe anybody, a policeman or anybody else, just because of his occupation? CPS brought these charges to the Harris County Attorney's Office, and the Harris County Attorney's Office caused this petition to be filed with the clerk's office because of what these two women employed by Herman Memorial Hospital said, and I have yet to speak in court. I have yet to tell what happened, my side, and so has my wife. My wife has not been able to tell the judge what she has to say. He won't let her. Her lawyer won't let her. I told my stupid ass wife not to listen to her fucking mother, that they call her mother has done nothing but ruined our lives. Now she listened to her mom, and this lawyer that this judge appointed, women were in the courtroom begging my wife, that judge is corrupt. Don't take this lawyer. She did it anyway. This lawyer has done absolutely nothing. Absolutely nothing. And in the proper time, her ass will have a complaint with the state bar, file against her. And if the state bar don't take care of business against her, then those who 34 minutes before this stops recording. So let me get back to this. I want to get closer up. Anybody going to believe anybody, a policeman or anybody else, just because of his occupation? As I told you, the burden stays with the state. I'm telling you again, the burden of proof, fuck evidence, proof is what I go by, remains with the state of Texas throughout the trial. and never shifts to the defendant. That's what they say, but in actuality, that's not what really happens. The defendant doesn't have to put on any evidence, just proof. The state charges. It's up to the state to prove if they, so the state is a they, can. I believe that's all I'm going to say. Ms. Mankey, thank you, Your Honor. The court. You want any warning on your time? Mr. Mankey, yes, sir. How much? 5 minutes, please. Now, how about you, Mr. Webb? Mr. Webb, that would be fine. So, as I was saying, ladies, people, my child is, when I say stole, commit theft, I'm not like, delusional. I'm well trained in the law. God taught me law through a judge of the Texas Court of Criminal Appeals whose name was Marvin O. Period. So I don't know what his middle name was. T. And he was hated not only by other judges, but also those judges on the Court of Criminal Appeals. They would attack him when he would dissent against the majority. And they soon learned early on when he became a judge on the court that rather than to respond to his dissenting opinions, that it was in the best interest to not respond, because to them they learned that was like pouring gasoline on a fire. And he was also a comedian. Made them all look like damn fools. He used to be an inmate. He used to be a defense attorney. And he ran for a judge of the Court of Criminal Appeals, and he got on, he won, and he stayed in office until he died. He was a great man, and God used him to teach me law. So they can't fuck with me when it comes to law. None of them. I don't give a damn who they are. What God teaches me through man, let no man unteach. So in this case, before I would discuss the merits or facts of the case, the elements, first, that court, as opposed to that judge, has to have what is called jurisdiction. And the only way the judge, or rather the court, would get jurisdiction over my person is that a constable or some other law enforcement official serve me with a duplicate as opposed to a copy of the petition. I never got that. Therefore, the court lacks personal jurisdiction, just subject matter. In this case, by subject matter, that court has subject matter jurisdiction over the case. Child abuse. But does the court have jurisdiction over my person? No. Without both subject matter jurisdiction and personal jurisdiction, the court cannot proceed. A judge does not have jurisdiction. A judge gets what we call judicial authority. Without judicial authority, he cannot talk to me. So fuck Judge Phillips. Fuck him. He is corrupt. I have no respect for people in public office that are corrupt. No respect whatsoever for any motherfucker in public office that are corrupt. Do you have respect for a child molester, a rapist, a murderer? Do you have respect for him? Why? That she has committed a crime against humanity.